Hello, thanks everyone for joining our training today. We're going to give everybody about 1 more minute to log on, and then we'll get started with the training. All right, we're going to get started. Thank you everybody for joining. My colleagues Rachel and Dahlia are going to come on the screen shortly as well. Rachel, could you move to the next screen, please? While she's getting that set up. So welcome everybody to our second part of our asylum training. Today's training is going to focus on the real nuts and bolts of putting together an asylum case and presenting your case before the asylum office or the immigration court. If you missed the first part of the training on Monday, that training focused on asylum law. So if you missed it, you'll need to get caught up at another point because the legal part is very critical to what we're going to be talking about today. But today's training will be more interesting, we think, in that it talks about how as attorneys we can really make a difference in these cases and help ensure that the asylum seekers we work with have the best possible chance for success. As I mentioned, I'm here with my colleagues Dahlia and Rachel. My name is Ashley Huebner. I'm an Associate Director of Legal Services at NIJC. I oversee our asylum program and our children's program at NIJC. Rachel and Dahlia are the other two components of our asylum pro bono program, along with Anna Sears, who many of you may have emailed with in the past, who's our pro bono coordinator. If you take on a case with NIJC, you will likely be coordinating with one of us or more of us as you prepare your case and move forward with representation. A few housekeeping matters before we move forward. We have in the handout section of the control panel, you'll see 3 different handouts: the agenda for today, a copy of the PowerPoint for today, and a document called Tools for Pro Bono Attorneys, which is sort of a one-page, one-stop location for all the resources you may need as you move forward with asylum representation. After the training today, later this week, you will get an email from us with your CLE certificate, as well as a copy of our current case list if you wish to take on a case at this time. As you know, when you registered for the training, if you do not already have a case with us, we do ask that you take a case within 3 months of attending this training. In addition, if you have any questions as we move forward today, please enter the questions in the question box on the control panel rather than the chat box. In the question box, we'll be able to track them as we move forward. We will answer the questions either through the question box or verbally as we move forward in the training, and we hope to have some time at the end to answer questions as well. And finally, everything we talk about today is discussed in much greater detail and with more resources on our website. We encourage you to take a look at our website at immigrantjustice.org. Become familiar with the website. That's where you'll find our asylum manual, practice advisories, updates regarding immigration law and procedure, which is very critical right now as things are rapidly changing in the immigration and asylum world. And everything we talk about today will be discussed there. So you don't feel like you need to take copious notes as we're talking today. Just go back to the website and get more information as you move forward. Next slide, please, Rachel. So before we get into the nuts and bolts of preparing and presenting your asylum case, I'm going to provide a very quick background in NIJC. If you attended Monday's training, this will be very familiar to you. But very quickly, NIJC is a legal service organization based in Chicago with offices in Indiana, San Diego, and DC. We provide immigration legal services in all areas of immigration law outside of employment-based immigration, student visas, and tourist visas. We serve approximately 10,000 non-citizens each year, and we serve many of those non-citizens through our network of pro bono attorneys like you all, who work on many of our pro bono matters, including asylum matters, and help us serve the high volume of non-citizens that we are able to serve. What makes NIJC unique among immigration legal service providers is that while we have a very high volume direct representation practice, we also do substantial impact litigation, policy, and advocacy work. And we think this is very critical to the work that we do and the focus on our clients and the non-citizens that we work with, because we're able to leverage and utilize the information that we learn from our clients, from the experiences they share with us, from the challenges that they encounter in the immigration system, and use those stories and those examples to further our policy, litigation, and advocacy efforts. So it's not uncommon for a pro bono attorney to be working on a case with NIJC and to encounter an issue which then we are able to utilize and advocate on behalf of the client with members of Congress or through litigation efforts to try to make change for the client and also systemic change as well. Next slide, please, Rachel. So pro bono attorneys are very critical to the work that we do, in large part because non-citizens in deportation proceedings do not have the right to appointed counsel. They have the privilege of representation at no cost to the government. And what this means, practically speaking, is a vast majority of non-citizens who request representation from NIJC would likely be forced to proceed pro se if they were not able to obtain pro bono representation. Immigration law is incredibly complex. It's been compared to the tax code in its complexity. And during the past few years, asylum law has become one of the most complicated areas of immigration law. As you probably heard on Monday during the training, and as you'll hear today, asylum law and procedure is very complicated and confusing, even for attorneys and seasoned practitioners. So if you feel yourself getting confused today or felt yourself confused on Monday, think about how a non-citizen who's not a lawyer, who may not speak English, who may not have any familiarity with our legal system, would feel having to navigate this system on their own. So by providing pro bono representation, you are making a dramatic difference in the life of an asylum seeker because you are dramatically increasing the chance that that asylum seeker will be able to get protection in the United States. Next slide, please, Rachel. When you take on a case through NIJC, we think it's important for you to understand what it means to represent an asylum seeker from NIJC's perspective. When NIJC takes on a case for representation, we agree to provide representation to an asylum seeker even before we know there's a pro bono attorney available to take the case. And so that means if we can't find a pro bono attorney to represent that particular asylum seeker, we've committed to provide representation ourselves in-house. But of course, we are a nonprofit organization. We do not have endless resources to provide all the representation that is needed, and the need for asylum representation always exceeds the demand. And so every time you accept a case for representation, you are freeing up another slot for NIJC to provide additional representation to another asylum seeker in our service area. In addition, when an individual gets asylum, they are able to reunite with their spouse and children, and their spouse and children are able to obtain derivative asylum status through them. So if you represent an asylum seeker and are successful in your endeavor, you are also ensuring that your client will be able to maintain family unity or reunite with family members they may have to have left behind when they came to the United States. Next slide, Rachel. And then finally, we like to provide a very quick overview about how our pro bono programs work so that you understand what your client went through, the process they went through at NIJC, who they talked to before they get to you. Because by the time many of our clients reach their pro bono attorneys, they've had to navigate many different systems, work with many different individuals, and it can be very confusing. And so it's very important that they be able to understand your role and connection with NIJC as you start to explain the process to them. So non-citizens reach out to NIJC in a wide range of ways requesting representation. We have relationships with many community organizations, religious organizations, schools, hospitals, governmental organizations who make referrals to us of clients, and clients contact us directly as well. Clients hear about us through our immigration court help desk at the immigration court. They hear about us through friends and family who've received services from us in the past. However they get to us, if an individual is requesting asylum, our asylum program will conduct an in-depth legal screening to determine if the individual has a viable claim for relief based on the case law as we believe should be applied. And we determine if we think that representing them would be a good use of pro bono resources, that this case would be a good fit for pro bono attorneys, as well as ensuring that the client is income eligible for our services. If we accept the case for representation, as I mentioned before, we will sign a retainer agreement with the client at that time, even before we know we have pro bono counsel. And then we begin to look for pro bono representation, in large part through our case list, which, as I mentioned, will circulate after the training today. If a pro bono attorney wishes to take on a case, they contact us, and then they become the primary attorney of record. So you, as a pro bono attorney, would take on a case, and you would be meeting directly with the client, preparing affidavits and briefs, gathering supporting documents, and then appearing at the asylum office or the immigration court. But we are here every step of the way. We recognize that most, if not all of you, are not immigration attorneys. This may be the first immigration matter or asylum matter that you have dealt with. And we want to ensure that you feel supported and have the best chance of success in representing your client and obtaining protection for him or her. So in addition to all of the resources available on our website, we, myself, Dahlia, Rachel, and Anna, are here every step of the way for any questions that may come up, including reviewing your filings and your documents as you proceed. All right, so with that intro done, I'm going to turn things over to Rachel, who will provide the first information about how you prepare your case and move forward with representing your client.
Hi, everybody. So I am now going to get started and talk to you a little bit today about how we're going to take all this law and how we're going to put it together working with your clients. So we like to start out by really saying that when you're going to work with an asylum seeker, it's going to be a lot different than working with any other client that you've worked with before. Asylum seekers are coming to the table, after fleeing persecution in their home countries. They've oftentimes left behind family and friends and their home, and they're coming to a new country where oftentimes they know no one. They don't speak the language, and they're really needing to start over again. They've gone through significant amounts of trauma, and so really when they're going to meet with you for the first time, oftentimes working on their asylum case and trying to prepare the best asylum case is not going to be first and foremost in their minds. So sometimes immediate needs like, how am I going to feed my family? How am I going to find housing? Can I get a driver's license? I'm seeing someone here and I'm thinking about getting married. Is this going to be an avenue for me to get status in the country? Are going to be other things on their minds? So sometimes these are things for you to think about and consider. Also, when you're starting to work with an asylum seeker, it's going to be really difficult for them to talk about what happened to them, what they went through in their home country. So knowing that those discussions and getting them to open up to you and feel free talking with you is going to be a difficult thing. That's going to take some time and some relationship building. In addition, because of trauma, it can be PTSD that they've suffered. It could be physical abuse, injuries to their heads or other parts of their body that contribute to memory issues and inability to remember what happened to them, or them blocking things out because it's too hard to talk about. So knowing that, they're going to come to the table with all of these things, and these are things that you're going to need to be ready to kind of deal with and be prepared for as you start on this asylum journey with your clients. Again, this is just kind of a refresher and a reminder that asylum seekers come to us in different postures. Some of them enter lawfully and, plan to just come for a visit to the United States, and then sometimes something changes back in home country that makes them afraid to return home. So they may be applying affirmatively for asylum, in which case they would be applying at the asylum office. In other instances, we have clients who have come into contact with immigration officials when they first came into the country. And so what they're going to be doing is you're going to be representing them in immigration court. We have clients of all ages. So sometimes your clients are going to be unaccompanied immigrant children. And sometimes we're going to have family groups that are going to be your clients in these asylum cases. So just a refresher that, based on the type of case that you decide to take on, you may be coming into contact with a number of different individuals and different entities. Last time as well, we talked a little bit about the asylum system and really how there are two different tracks that your clients can be on if they are applying for asylum. The first track is what we call an affirmative posture. And this is for an individual who is seeking asylum who is not currently in removal proceedings. In these instances, again, this could be a client who entered lawfully on a tourist visa or a student visa or some other kind of visa, and then after a period of time, they decide that they want to apply for asylum because they have a fear of returning home to home country. Or it can be just for an individual who entered without ever encountering immigration officials at any point in time, and they decide that they want to file an application for asylum. In those instances, those individuals will be filing their asylum application with USCIS, United States Citizenship and Immigration Services, and they will be going for an interview at the asylum office. Other clients are going to be applying defensively, is what we call it, and these are individuals who are currently in removal proceedings, so they have come into contact with immigration officials, and notice to appear has been issued for them, so they are before the court. They are admitting that they are not here lawfully, but they are saying that their defense to being removed and returned back to their home country is that they are eligible for and deserving of asylum. So for those individuals, you will be representing them in immigration court before the Department of Justice. And after they present their asylum cases in immigration court, if they are unsuccessful there, then they will appeal up to the next level, which is the Board of Immigration Appeals. And again, if they aren't successful there, they have an opportunity to petition the Seventh Circuit to see if the Seventh Circuit will take their case. Again, another refresher for you from last time. Ashley walked you through all of the elements of asylum, but we like to bring this back up again to remind you and kind of keep these things in the forefront of your mind as you start taking on an asylum case. The things that you are really going to need to prove when you take an asylum case are that your client has a well-founded fear of persecution that's perpetrated by the government or by an entity that the government cannot or will not control, and that your client was persecuted on account of one of these 5 protected grounds. And we really like to separate them out and parse them out like that, because that's the way we like you to think about presenting these cases, is that I need to prove each and every one of these elements in order to ensure that my client is eligible for asylum. In terms of what you're going to be filing, the majority of the documents are very similar. So if you're presenting a case affirmatively at the asylum office, or you're presenting a case before the immigration court, the majority of the documents are very similar. In both cases, you're going to be filing an appearance form, but if you're filing your appearance in front of the asylum office with USCIS, you're filing something called a G28. If you're filing your appearance form in immigration court, you're filing something called an E28. The critical difference is that obviously if you show up in immigration court with a G28, you're out of luck. And if you file an E28 with the asylum office, you're out of luck. So an important small distinction there. In both cases, though, you're filing an asylum application, which is called the I-589 application. And then either before your asylum office interview or before your merits hearing, you're filing very similar documents as well. And you're going to spend the bulk of your time working on these documents. So in both cases, you're preparing either a legal memo or a brief. This is where you're going to outline those asylum elements, and you're going to establish your client's eligibility for asylum, and you're going to make your legal arguments there. In both cases, you're going to be preparing your client's affidavit or declaration, and you're probably going to spend the bulk of your time working with your client here. In both cases, you're presenting an annotated index, which is going to collect all of your supporting documentation, all of your evidence and corroborating documents that you're presenting, and then you're just pulling out those critical pieces and sharing those with the court or with the asylum office. Another big difference to note is that if you are presenting your case in immigration court, as opposed to at the asylum office, you will have opposing counsel. And so anything that you're filing with the immigration court, a copy of any of that needs to be served on your opposing counsel as well. Now we're going to turn a little bit to just talking about working with your client and some tips and best practices there. So again, this is a reminder from last time. Dahlia talked to you a little bit about this. When you first get a case from NIJC, before you even think about kind of meeting with your client or speaking with your client, we recommend that you go through the file that we send over to you. And in that initial file that we'll send you, there'll be a number of things. First thing there'll be in there is a cover letter that will highlight all of the sort of critical deadlines. It will talk to you about your client's posture, letting you know if they're in an affirmative posture or a defensive posture. We'll give you critical contact information for clients. But most importantly, it will give you all of the case notes. So all of the conversations that we've had with client up until this point, all of our conversations, our thoughts in terms of their eligibility for asylum, the basis for their claim as far as we have determined up until this point. And then in addition to that, they'll have a number of intake documents. So if they came to us with any documentation, their passports, if they had any immigration paperwork and documents, that will already be in the file. So you'll have a chance to sort of get to know your client a little bit in paper format before you even meet with them. A second thing that we recommend that you do right away is file your appearance with the immigration court or with USCIS. So filing that E-28 or filing that G-28. The reason we think that's so important is that once you have your E-28 on file or once you have your G-28 on file, then you will receive a courtesy copy of any correspondence that those entities have with your client. And it's just great to know if your client's court date changes, you will get a courtesy copy of that notice if your E-28 is on file. And you just want to know about those upcoming events and deadlines. The next thing we recommend is calendaring all deadlines. We list 3 critical deadlines here. So the first one is employment authorization. Dahlia is going to talk to you about that in a little more depth later. Basically, after your client applies for asylum, after a set number of time, they're eligible for a work permit. And those work permits are really critical to our clients in terms of being able to get by and survive here in the United States. A second is obviously going to be court hearings. And then the third is the 1-year filing deadline. And that is if your client has not already applied for asylum, they need to do so within 1 year of their entry to the United States in order to be eligible for asylum. And then the last thing we list is to check the EOIR information line. The number is listed there. This is basically just an automated hotline, which allows you to call and check on your client's court date. So if your client already has a court date, it's good to check in on that deadline. If your client has what's called a notice to appear, which is a charging document, but that charging document has not yet been filed with the immigration court, you're going to want to check on that regularly to see if that document has been filed with immigration court, because that is the point that you're going to know that your client is in removal proceedings. Another thing that we like to talk about with our pro bono attorneys is really there's these 3 critical pieces that you're going to be working on when you're preparing an asylum case. So really it's your client's affidavit, it's preparing your legal arguments, and then it is collecting and gathering corroborating evidence to help support your client's asylum claim. And really we think about these 3 pieces in flux. So there's really no start with the affidavit, then move to corroborating evidence, then work on your legal argument. We see these things more as shifting and changing and moving. So for example, sometimes when I'm working on a client's affidavit, I'll be talking to my client and they'll tell me that when the police officers came to my home, my husband was there and my oldest daughter was home, and the police, arrested me, handcuffed me, and took me away. At that point in time, I make a note to myself and I think, hey, husband was home and oldest daughter was home at this point. I'm going to try to get supporting affidavits from those 2 individuals so they can corroborate this piece of my client's story. So really then I might move into my corroborating evidence and I might try to start working on those affidavits in tandem with my client's affidavit. Another example is when you first get a case file from us, initially we might say this is a political opinion case. Based on what we know that client participated in these demonstrations, and after they did so, they were arrested, and they were harmed because of it. So when you get the case file, you may have started your legal argument already in your brief saying this is a political opinion kind of asylum case. But then in further conversations with your client, you realize, hey, this client also suffered a lot of domestic abuse at home at the hands of her husband, and she tried to leave him on a number of occasions and she could not do so. So all of a sudden now you should be thinking, hey, wait, maybe now we additionally have a particular social group argument that we want to make as well. So that legal argument is going to shift and it's going to morph and it's just going to change a little bit. So try to just keep that in mind as you're working through these cases. The first step usually when we start working on these asylum cases is to meet with your client. And in that first client meeting, what we try to really focus on is it's just about building rapport with your client. You want to get to know your client, you want to meet your client, you want to introduce yourself, make small talk, get to know them. If they have kids, ask about their kids. It's really not an opportunity to dive into the meat of the asylum claim right away because that is such a difficult thing to talk about. So really it's an opportunity for you just to meet, to explain your role, to explain who you are. And in this COVID climate, I think it's difficult because you don't get to meet your client in person, sitting down together, which is the way we would like to do things always. What we have seen happen is in a number of cases, our pro bono attorneys have decided to set up a Zoom call for their first client meeting. And that way their client gets to see them. It's not just a random voice on the other end of the phone line. They actually start to build a connection with them. So that might be a great way to get the client attorney relationship started with them. One thing as well in this COVID climate that's a little bit difficult when you're working with clients is we don't know where clients are talking to you. They may be at home, there may be a number of individuals around them, and it's really important that you're able to speak with your client one-on-one and that your client feels comfortable opening up to you and speaking to you about all of these sensitive things that have happened to them in their past. And maybe client's not going to be comfortable talking about past abuse in front of her small children, or not comfortable talking about past abuse in front of her current partner. So what you're going to want to do right away is really talk to your client and ask them, are you in a safe place to talk? Are you in a private place? Talking to them about confidentiality and letting them know how important it is that you're able to have a private one-on-one conversation with them about their case. Oftentimes clients want you to meet their family members, or their partners want to be there, or other supportive individuals want to be there. So we always think it's a good idea to meet those family members or those supportive individuals as necessary, but then asking them to step out and making sure that your client is there in a safe space to speak with you one-on-one about their case. It's also a good opportunity for you in that first meeting to just get to know about your client's life here and now. It's a safer thing to talk about most of the time, understanding where they're living, what they're doing, if they have kids, if those kids are in school, what's going on with them, and then making a plan for how you're going to attack your asylum case together. Communication is one thing you're going to want to talk about. So how can we communicate with you? Is it best to call you? Is it best to text you? Is it best to email you? Trying to get a number of phone numbers just in case first phone line doesn't work anymore. Is there a second contact? Is there an additional person that I can contact if I can't get in touch with you? So making sure you have that information is going to be really, really important. We're definitely seeing, clients in difficult situations these days in terms of instability with housing, losing jobs, not having work. And so, not being able to pay phone bills is a real problem and issue at this time. So really kind of thinking those things through so that you don't lose those lines of communication with your client. Also thinking about setting up meetings. How are we going to meet? When are we going to meet? When are good times for you to be able to talk with us? So setting up those plans for communication. And then really kind of making a roadmap for them, letting them know, we're helping you with your asylum case. Here are the pieces that we need to put together, letting them know you need to work on an affidavit, and that is probably going to require a number of meetings together. Letting them know that you're going to need to work on, collecting corroborating evidence with them, and maybe needing additional information about other people for them, and really explaining how the asylum process works. And, we're going to go to a hearing on this date. We're going to wait this number of weeks. We're going to file these types of documents. So sort of explaining those things to them. Additionally, you're going to explain your engagement letter. Oftentimes, engagement letters are tricky and full of legalese, and you really want to make sure your client is empowered and understands what they're signing and what they're doing and what the scope of your representation and your relationship is going to be with them. So you're really there to represent them for their asylum case. If they have family law types of issues or criminal issues or other types of issues, obviously you can tell them that they should come to you with that information. They should share those concerns and those problems with you, but you are not a criminal attorney. You are not their family law attorney. You are here to work with them on their asylum case. But if they do have those issues, they can bring them to you. You can bring them to NIJC. We will try to find resources for you to support in those types of things. And then finally, we usually, when we used to be able to meet with our clients in person, we would use that first client meeting to sign forms. You're going to need to file a number of different things on behalf of clients in which you're going to need client signatures on those documents. So oftentimes we recommend in this first meeting now in COVID times, just letting clients know that you are going to need them to sign a number of different documents, and kind of walking them through those documents. If you're on a Zoom call, showing them those documents so they can see those documents, showing them what they're going to need to sign, and then letting them know you're going to be putting those documents in the mail for them so that they can sign those for you and get those back so that you can represent them accordingly. So the second step, the next thing that you're going to do is you're going to obtain your client's immigration history. So there is no discovery in immigration court proceedings. So what you're going to need to do in order to get any contacts that your client has had with immigration officials is to file a FOIA request. If your client is already in immigration court proceedings, you can file an expedited, they call it a track 3 request, so that you'll get that FOIA information more quickly. But definitely, you want to know if your client came in, they met with immigration officials, they made any statements to immigration officials. You want to know what they said, so that you have that information, so that you can compare that with the information that you are getting from client to make sure that everything is going to be consistent, or that you can explain away any inconsistencies in their story. Another thing that you can do to get information about your client, if your client has already appeared in immigration court on a number of occasions, is that you can actually go to the court. You can file a request with them to review the court file, and then they allow you to come into the court and actually review the entire file of any documents that have been filed. And they also have tapes of the hearings. So if your client already went to a hearing and made certain statements to a judge, you can sit and you can listen to those statements as well. If your client was an unaccompanied immigrant child, they oftentimes, when they came into the country, they were picked up by immigration officials and they were placed in the Office of Refugee Resettlement in a shelter there. And so sometimes when they're in the shelter, they've made statements, they've had meetings with counselor, their therapist, they've had medical exams. There's a wealth of information oftentimes in those ORR documents. And so you can file what's called an ORR records request there. Another thing that you'll do next along the way when you're presenting your asylum cases to get the ball rolling is to file the skeletal asylum application. Now, oftentimes by the time you take a case from us, this step has already been taken care of. But we just want to give you kind of a brief introduction to what the I-589 looks like. It's a very short form. It's about 10 pages long. It just contains basic biographic information about your client. And then as you can see, it just kind of has very basic questions about why your client is applying for asylum. So you can see here, one of the questions says, I am seeking asylum or withholding of removal based on race, religion, nationality, political opinion, membership in a particular social group or torture convention. So you'll just check the requisite boxes. And then it will just ask a couple of questions. Have you been harmed in the past? What happened to you? Why are you afraid to return to your home country? So it just really outlines the essentials of their asylum claim. Now, where you're going to file the asylum application is going to depend on if your client is in immigration court proceedings or not. So for adult clients who are not in removal proceedings, you are going to file their applications with the Nebraska Service Center or with USCIS. So those are individuals who are proceeding affirmatively, or they're in an affirmative posture. For adults who are in removal proceedings, you are going to file their asylum application with the immigration court. And there's really a couple different ways you can do that. You can file at the immigration court window. Immigration court is still open, so you can file in person there. You can mail in the I-589 application, or in the days when they were actually having master calendar hearings at immigration court, you could bring a copy of that application and file it in open court. Unaccompanied immigrant children is kind of an exception to the rule. So unaccompanied children, even if they're in removal proceedings, they have the opportunity to file their asylum application with USCIS and the Nebraska Service Center. And the reason behind this is because they're children, it is thought that proceeding at the asylum office, where they would be interviewed by an asylum officer in a non-adversarial setting, would be better for children, less challenging for them to present their cases there. So they are allowed to present their cases and to file their applications with USCIS. So now we are going to have a little poll. So the question here, and we're meeting with our friends Christopher and Norma again, who we met on Monday. And the question is, where should Christopher and Norma file for asylum? So I will let you guys review these hypos again. Christopher is our teenager from Venezuela. He was designated an unaccompanied child and placed in removal proceedings when he first came to the US. And then we have Norma, who is a woman who is in immigration court proceedings with her children. So after everyone has a minute to take a look at that. think Ashley was going to help me with the poll.
The poll is running, Rachel. You might not be able to see it on your screen. I'll give everybody about 30 more seconds, well, 15 more seconds. It looks like we got a good response rate. And then I will read off the results for you, Rachel.
Excellent, thanks.
All right, 5 more seconds. Okay, so the poll is closed, and it looks like 40% thought that Christopher should file at the immigration court because he's in removal proceedings, and 60% said at the asylum office because he's an unaccompanied child. So Rachel, I'll let you discuss that quick.
So Christopher, because he's an unaccompanied immigrant child, is going to get his first shot filing with the asylum office. So again, kids are kind of special. They're in that special zone, whereas normally, you know, if someone is in immigration court proceedings, they would file with the immigration court. But because Christopher is an unaccompanied immigrant child, he first gets to file with the asylum office. So yay, 60%.
All right, we'll kick off Norma's poll right now. Same question. All right, about 10 more seconds. All right, we're closing the poll. And it looks like 71% said at the immigration court because she has a court hearing, and 29% says at the asylum office.
All right, so the majority wins on this one. So because she's an immigration court proceeding and she's an adult, we know that she is going to file her asylum application with the immigration court. So now we'll move on and start talking a little bit about the affidavit. So when you're presenting these asylum cases, I would say the most important thing that you are going to do with your client is work on their affidavit and drafting a complete, comprehensive affidavit with your client that really encompasses their story. Credibility is going to be the most important piece of their asylum case, and the judge can base its entire decision in your case on whether they think your client is credible or not. And so the main thing they're going to focus on is your client's affidavit that you draft, and then they are going to compare that with your client's interview or their client's testimony at trial. So we would say spend the majority of your time here working with your client on putting together a really strong affidavit. How are you going to do that? We'll talk about that. But first, know that working on an affidavit with a trauma survivor, and all of your clients are survivors of trauma. All asylum seekers have gone through something extremely traumatic to bring them to the United States and lead them to a place where they're afraid to return home. So here's just some tips and some things that we found that are going to be helpful when you're trying to work with an individual who has gone through something that our clients have. The first thing is sometimes because it is so exhausting and draining to talk about trauma and to talk about these really, really difficult things that have happened to our clients in the past, we recommend that you try to meet frequently with your clients, but for shorter periods of time. So sometimes it's just really helpful to let them know at the outset, we're going to meet today, we're just going to meet for an hour, or we're just going to meet for 2 hours, letting them know at 10 o'clock or at noon today, you will be done talking about this, but we need to, have this conversation about what happened to you so that I can understand this. Just putting a clock on it sometimes, reassures them and lets them know this isn't going to last forever. I know it's going to come to an end, and it's going to help them to relax and sort of prepare themselves for what they're going to need to go through. The second thing that we find really critical is providing your client opportunities to make choices. So asylum seekers are people who, had to flee their home countries. They had no choice. They had to leave. They probably did not want to leave their homes and their families and their lives and come to a place where they don't know anyone and they don't speak the language, but they just honestly felt like they had no other option. So now you want to give them as many choices as you can. Oftentimes when we would meet with clients in person, it would be simple things like, do you want to sit over here or do you want to sit over here? But when you're meeting with clients and you're working on drafting an affidavit, something I find really helpful is letting clients know we're going to need to talk about, these 5 things. We're going to have to talk about your childhood. We're going to have to talk about, these instances and these interactions that you had with gang members. We're going to have to talk about this one really bad thing that happened to you. We're going to have to talk about your flight to the US. We're going to have to talk about your life now. And then we're going to have to talk about all the reasons that you're afraid to go back home. What do you want to talk about today? And really giving them that ownership and that choice about, making decisions about where those conversations are going to go on specific dates. Another thing that's really helpful is explaining why you're asking the invasive questions that you're asking. So oftentimes you're asking really difficult questions. You're asking someone, you said you were abused by your partner. How did they abuse you? Did they physically abuse you? Did they emotionally abuse you? Did they sexually abuse you? When you say they physically abused you or beat you, what did they beat you with? You're asking really difficult questions about things people don't want to talk about. So it's important to explain why are you asking them these things? So why do you need this information? So letting them know when we're presenting your asylum case, one of the things that we need to prove is that you suffered persecution. You were harmed very badly in the past. And the way that we do that is by providing these instances. And oftentimes I tell my client, if we're able to detail this in a lot of detail in a written affidavit, then oftentimes the judge or the officer in the asylum office is not going to ask you about these things in detail in the future. So if we can just work through it now and write it down for them, then hopefully you're not going to have to talk about it again in as much detail. Another thing that's helpful is just asking short questions, not compound questions, so you really are sure that you're getting the answers that you need. And then just knowing that, because of trauma, we talked about how oftentimes asylum seekers are going to have memory issues. They're going to suffer from PTSD or depression. They're not going to remember everything, and things are going to flood back to them in different orders. So they're going to give you pieces of stories here and there, and they're going to have a difficult time with dates and remembering when things happened. Sometimes these instances of persecution took place 10 years ago or 15 years ago. And think about trying to remember and recounting a story to someone about things that happened to you such a long time ago. So knowing that they're going to give you these bits and pieces of a story, and it's going to be your job as the attorney to weave all of these things together into a cohesive, comprehensive story that helps to establish their eligibility for asylum. And then finally, one last thing that we always say is just bookending your interview, starting off with something light, chatting with them about the weather or about kids or about school or about how their morning was. And then as you're leaving again, trying to lighten the mood, take them away from this past persecution time that they've been stuck in and talking to them just about, are you doing anything for Halloween, or do you have any fall plans, or just kind of trying to take them back into the present and take them out of this trauma that they have been having to kind of go back to with you. So when you're preparing the affidavit, as we've mentioned, this is where we'd recommend really spending the bulk of your time with your client, is really working on weaving a comprehensive story for them. And you're going to need to meet a bunch of times, and we'd say, yeah, do it now. Meet right away with your clients and get started on this. The things that we like to really think about is, number one, maintaining your client's voice. So this should sound like your client talking. It shouldn't sound like legalese. It shouldn't sound like an attorney drafted it. It should sound like your 7-year-old client, if you have a 7-year-old client. It should sound like your educated 35-year-old professor client, if it's your educated 35-year-old professor client. So really thinking about that as you're writing. The second thing is, putting things in chronological order and providing necessary background information. So starting off with your client's childhood, setting the scene. We want the adjudicator to understand, who your client is as a person, where they come from, what their life experiences look like, and then, giving them the information that will help provide context for their asylum claim. Providing the, who, what, where, when, why, and how. So who harmed your client? What happened? Why did they do it? How did your client respond? Why did they flee to the United States? Why are they afraid to return? So all of those things should be part of that affidavit. All of the asylum elements should be included in there. And then considering length and detail are important. So probably you're going to need to have at least a 10-page affidavit to really comprehensively tell your client's story. It could be longer than that, but I would say probably not too much shorter than that. And oftentimes we talk a lot about detail. So obviously you want there to be a sufficient amount of detail for your story, but you don't want to tie your clients to minuscule details that don't really matter. So if your client says that they were attacked the first time, back in May of 2015, you don't need to press them. Was it May 11th? Was it May 12th? Just in May of 2015 would be sufficient, because you don't want to write something in the affidavit and then later when they're testifying at trial, have them say a different date and create a credibility issue for your client. Same thing goes with other minute details that don't really matter. If your client says he was attacked by a number of gang members, it probably doesn't matter if it was 5 gang members or 7 gang members. So really just knowing that, using details when they're critical, but really trying to make sure that you're not pinning your client down to too many things that might trip them up and create credibility issues for them later when they're nervous and they're testifying at trial. And then the final thing is really checking for consistency with those other documents. So as we mentioned before, your client may have had contact with immigration officials when they first came into the country. They may have been interviewed. They may have made certain statements. You want to make sure that their affidavit that you are drafting is consistent with those earlier statements that they have made. And if there are inconsistencies or there are omissions in that earlier statement that was made, trying to understand why, and maybe including some information in the affidavit about those inconsistencies. Here are just a couple of examples of sort of the beginning of an affidavit and what they normally look like. So a couple things that you'll see is normally what we recommend is at the beginning of the affidavit, starting with an introductory paragraph, which really just summarizes the basis for your client's asylum claim. So why are they applying for asylum? In this example on the right, I'm applying for asylum because I'm scared I'll be hurt by my aunt, father, and men from the gangs if I return to Honduras. So we get a little bit of information right off the bat. The reader knows, oh, this is why my client is applying for asylum. And then what you're going to do is you're going to walk through all of the different parts of their case in chronological order. So oftentimes we use subheadings to really divide up the affidavit, make it easier to read for the adjudicator, and also to highlight critical events in the story. We always start with, where they're born, what their childhood was like. We try to set the scene a little bit before we get into the instance of persecution, their flight to the United States, their life in the United States, and then why they're afraid to return back home. But all of those elements should be incorporated into the affidavit. Okay, it is time for another poll. So here we have a statement, a couple of statements from a client affidavit or declaration. And I want you guys to think about, what statements in there would you kind of add or change or think need to be changed in order to make for a good affidavit.
Because the poll will cover up the PowerPoint slide, we'll give you 30 more seconds to look at the slide, see the issues that you see there, and then I'll launch the poll. All right, we're going to launch the poll. All right, about 10 more seconds. All right, we're going to close the poll. And share the results here. So Rachel, 66% said too many details, 55% says it uses legal terms, 48% says client tone and word choice, and 28% said the particular social group isn't viable.
Okay. So I'd say for the most part, yes, yes, yes. So too many details for sure, right? So in here we see 3 gang members driving black motorcycles. So do we need to, include those kind of details there? Doesn't matter if it's 3 gang members or several gang members. Black motorcycles, again, a detail that maybe is going to trip up your client later. So something we wouldn't need to include. And again, the date, May 1st, 2010. Maybe we don't need to include such a specific date unless it's a critical date for some reason. Legal terms. Again, the term persecution isn't usually a word that a lot of people throw around on a regular basis. So probably client would say something more, I was harmed, I was beaten, I was threatened, instead of the word persecuted. Client tone and word choice, I think that falls into the same bucket, right? So saying that you were accosted and harassed. Again, maybe your client would say that, but possibly not. And then the last thing, the particular social group not being viable, I would say we would disagree with that one and say that Salvadoran females in relationships they are unable to leave is a particular social group that we argue oftentimes in a lot of our cases. Ashley touched on this a little bit the other day, and it's definitely something that would, is a complicated concept that we'll definitely talk about in more detail as you take on an asylum case. But we would argue that that PSG is a viable one in the 7th Circuit. So as Ashley mentioned, we provide a lot of support throughout the life of these asylum cases after you take a case from us. And one of the things that we are happy to do is to look over your affidavit. So after you have a draft of that affidavit, we love to take a look at it just to make sure you're sort of trying to incorporate all of these critical elements into the affidavit just to make the strongest affidavit for your client possible. And I would say the 4 things that we see most frequently when we're taking a look at these affidavits is that, number 1, it doesn't sound like client. There is some of that legalese in there. Sometimes we see, cites to exhibits or see attached exhibit A type of thing in the affidavit. That wouldn't be something your client would ever say. So it's definitely not something you're going to want to include in that affidavit. Another one is the asylum elements. So really, we want you to be thinking as you're drafting this affidavit, this isn't just my client's story. I am really trying to establish their eligibility for asylum through this affidavit. So have I hit on, who the persecutor is? Have I talked about what type of persecution my client suffered? Have I talked about the nexus? Why was my client targeted? Was it on account of their political opinion? Was it because they are a Salvadoran woman in a relationship she is unable to leave? And then, also I think oftentimes people forget about the unable and unwilling to protect element. So, if your client didn't report to police, you still have to make the argument that the government was unable and unwilling to protect them. Well, how are you going to make that argument? So including some language in the affidavit where a client says, I never reported, my husband's abuse to police because I knew they wouldn't help me. I knew this because, and then including some kind of explanation so that we really see that asylum element coming through in the affidavit. And I would say the most important one that's often lacking from these affidavits is just emotion coming through. So asylum is really about fear. Your client is afraid to go back to their home country, and really making sure that that fear and that emotion comes through in the affidavit. Another 2 things that we sort of check for is internal consistency with other documents. So sometimes you'll have an affidavit from your client, but you'll also have an affidavit from their spouse or from a child or from a friend or from another family member. We'll cross-check those affidavits, and all of those things should line up. Critical dates should line up. Important events should line up. So really making sure you're kind of checking those things yourself. And then finally, providing context and background. So oftentimes we'll see an affidavit and it will be about gangs in a Central American country. And affidavit will just launch in and it will say something like, I grew up in this small town in Honduras. A gang member threatened me, and so I fled to the United States, period. Without any context, without us knowing why was this gang threat so serious that you felt you had to flee the United States, it doesn't make a lot of sense. So first of all, giving some background about this gang, the gang's presence in your hometown, what sort of things this gang did, what happened to people that disobeyed gangs if they refused to join them or refused their demands, will be really critical and important for helping to put things into context. So the next step will, in addition to that affidavit and getting that together, will be corroborating your case. So normally, in an asylum case, the testimony of your client standing alone should be sufficient to sustain their burden of proof in an asylum case. But the court is going to require corroborating evidence unless your client either does not have the evidence and cannot reasonably obtain it. So what you're going to need to do, for example, let's say your client says that after they were threatened by the gangs, they went to the police and they made a police report. In that kind of an instance, the court's going to be expecting you to have that police report. If you don't have it, you're going to have to explain why not. You're going to have to explain why client didn't try to get it, or why client can't get it in that affidavit. And there are a lot of reasons why client couldn't get it. He could say, hey, my family members tried to get it and the police turned him away. Or he could say, I couldn't send my parents to the police station to try to get that police report because the gangs are monitoring and watching police stations. And if my family member were to try to go there, it would put them at risk and it would put them into danger, and I couldn't do that. And so instead of, providing that police report, you will provide an explanation about why he could not obtain that information. But really what you're going to try to do is corroborate your case in any way that you can. So on this next slide here, we can have just a bunch of different examples of types of places you're going to look for corroborating evidence. So one thing that we always do in an asylum case is provide country conditions evidence. You need to kind of go into an asylum case thinking that the adjudicator knows nothing about your client's home country, and so you need to educate them. So if it is a gang-based claim and your client is from a Central American country, you're going to look to a number of different resources, State Department reports, Amnesty International reports, newspaper articles, Ref World articles, any kind of information that you can find that is going to have information about your client's home country, and it's going to talk specifically about gangs, the prevalence of gangs, the MO of gangs, how they operate, how they work in your client's home country. In addition to that, you're going to want to have client-specific information. So you're going to need to prove up, just who your client is. You're going to need to provide identity documents for your client. Sometimes you're going to have those corroborating affidavits, like we talked about, from friends or family members to help bolster your client's asylum claim. Police reports we've mentioned. Sometimes 2 maps are going to be helpful pieces of evidence. If your client talks about how they lived in one gang's territory, but then they had to cross over into another gang's territory to get to work, and that put them in danger or at risk. Sometimes providing a physical map of the area can be helpful for the adjudicator to understand the situation. And then oftentimes too, we rely heavily on evaluators to help support our client's claim. So if client did suffer a lot of physical abuse, sometimes they will have photographs of those bruises and cuts and injuries. Sometimes they'll have hospital records. Sometimes they won't have any of that stuff, but we will try to get them set up with a forensic medical examination, a doctor who can document the injuries that your client has sustained. Other times your clients aren't going to have any residual physical injuries that are showing, but they're going to have a lot of emotional trauma. A lot of our clients suffer from PTSD or depression or have other mental health issues related to the instances of persecution that they suffered in the past. So we try to hook them up with counseling services. We try to hook them up with mental health evaluations, and those things can be helpful. Those evaluators often then will provide an affidavit that we will submit along with client's asylum application to help prove up that past persecution prong of their asylum claim. And NIJC has a number of resources we can connect you to in terms of helping you to find evaluators to provide those types of evaluations. Now, the final piece is that you need to prove that your client fears future persecution. And proving future persecution is a pretty tricky thing to do. So what we kind of often do is, again, rely on country conditions evidence showing, these are the current conditions in the country. Nothing has really changed there. Often, too, we rely heavily on expert affidavits. So again, we have a number of resources that we can point you to in terms of trying to find an expert on your country who could read your client's affidavit and read about what happened to them in the past and sort of make predictions about what they think would happen if your client were to return to their home country. Oftentimes too, it's helpful to find an affidavit from a similarly situated individual, if who's in kind of the same situation as your client, who's maybe currently still living in home country, but they're living in hiding, or something along those lines to help corroborate. So really, just thinking about all of those things. Here again, we're going to turn back to our hypos of Christopher and Norma. And we want you to take a minute to think about what type of corroborating evidence should you obtain in these cases. What do you think would be helpful?
Once again, we'll give you a few seconds to look through Christopher's paragraph, and then we'll launch the poll. All right, launching the poll. All right, about 10 more seconds. And closing the poll. Okay, so about 85% said police report, 95% said pictures of graffiti, 90% said affidavit from mom. Multiple answers were okay here in case anyone's trying to figure out this math. 100% said country condition evidence regarding the militias, and 65% membership card showing membership in an anti-government group.
Okay, so I would say, everyone's right this time, basically. Definitely, I think if Christopher could obtain that police report, that would be great. If he can't, remember what we're going to do is we're going to just explain why it was not, why he doesn't have it and why he could not reasonably obtain it. Pictures of graffiti would be great, again, to kind of prove up what happened. Affidavit from mom would be extremely helpful as well to corroborate Christopher's story. Country conditions evidence definitely would be helpful to kind of provide context for the adjudicator. I think the only one that's kind of a question mark would be a membership card for Christopher, because it's unclear from our hypo if he actually was a member of a political party or not, or if he just happened to be in the neighborhood where this anti-government protest was taking place. But I think you could ask Christopher, and if we had more information, then it is possible that that could be a good piece of evidence as well. So how are you going to get this evidence, right? So I would say number one thing that you can do is ask your client. Client, this is your client's case. This is more important to them than it is to anybody else. So really saying to your client, we need not only your story and your affidavit, we need to give the judge everything we can to help prove your asylum case to them. So who can we talk to? What can we find? What documents do you think we can get our hands on? And seeing what they can come up with. Now, one kind of disclaimer for that is if your client does come to you with a piece of evidence, always just do your due diligence and ask your client, how did you get this document? Oh, your mom mailed it to you. Do you have the envelope that she mailed it to you in? If there's anything about that document that does seem a little circumspect and you doubt its authenticity in any way, it's okay to leave it out. Sometimes I think clients feel when we ask them, do you have anything else? Do you have any other documentation? They sort of get worried and, occasionally, maybe might be taking whatever measures they can to get you documentation that they think that they need for their case. So just keeping an eye out for that. But I would say, that is the exception, not the rule. Another great thing about corroboration in asylum cases is that the federal rules of evidence do not apply. So you really can be creative in terms of what you are going to present and what is admissible in court. So for example, in a lot of cases, we see clients who receive threats from gang members, from family members, things of that nature. and they have text messages from these clients. You can take snapshots of those text messages and you can admit those as evidence in these cases. So really thinking a little bit just outside the box in terms of what you can admit and really, going for it. Another thing is that any documentation you submit needs to be translated into English to be submitted to the court or to the asylum office. So making sure you provide those translations and certificates of translation. One thing too is oftentimes you are working with a client and you need to get an affidavit from a family member who is back in home country. And there's always the question, how am I going to do that? So the easiest way that we find to do this is just to call the family member and ask a bunch of questions and draft the affidavit yourself. So we don't find it really successful when you ask a family member to write an affidavit and send it to you, because you're not going to get the information that you want or need. So we always recommend that you ask the questions, you guide the conversation, you draft that affidavit from client, and then what you'll do is you'll just read it back to them over the phone, checking and making sure that everything is true and correct. And then we often just submit that affidavit along with, we ask them to take a picture of their photo ID and to write out a brief statement that basically just says, I have this affidavit read back to me and everything is true and correct. They take a picture of that, they send that to us, and we submit those two documents along with their written affidavit that we prepared ourselves. So we always highly, highly recommend that you as the attorney are guiding the ship in terms of writing those affidavits, drafting those affidavits, preparing those affidavits. Your client, has the information, but you have the tools to organize that information, to really make sure that you are looking at it through the lens of presenting an asylum case. So make sure that you take the ownership over that piece of the case. And now I'm going to turn it over to Dahlia, who is going to finish up today by talking to you a little bit about presenting your case. So let me just give a minute to do this here. You're good to go, Dahlia.
All right. So hang on a sec, Rachel, I don't think it switched over. Okay. Hi, everybody. So I'm going to get started now talking about the different aspects of presenting your case, both at the asylum office and in immigration court, depending on the procedural posture of your case. So first, just as a brief refresher, Rachel did talk about this earlier, and we talked a bit about this on Monday, but the asylum system basically has two different tracks, and your client is going to be in one of the two different tracks. So there's the affirmative process, which is for if your client is not in removal proceedings, and that happens at the asylum office, which is part of USCIS. And so that is a non-adversarial process, which means you're not going to have opposing counsel, you're not going to be in front of a judge. Your client will be interviewed by an asylum officer, and there are two possible outcomes. Your assailant can either be granted asylum at this stage, which means that you're finished and everything is over, or your client will get referred to the immigration court, in which case you have to present the case again, but this time in a defensive posture. At the immigration court, if your client is in removal proceedings right off the bat, they jump straight over there, or they've been referred over from the asylum office. This is adversarial, so it's going to look more like a court. There will be opposing counsel. You will have to do a direct examination of your client so they can present their testimony. The government will have an opportunity to cross-examine them. And again, if they are successful at the immigration court level, then you're finished. If not, you have the option to appeal. So, we were just talking about gathering corroborating evidence and the type of corroborating evidence that is necessary for your case. And whether you're at the asylum office or at the immigration court, you're going to want to organize all of this evidence and create an index so that either the asylum officer or the immigration judge can see exactly what you're presenting in support of your client's asylum claim. This index is actually quite important because often asylum evidence packets can be quite lengthy, and so you want this index to be annotated so that the judge or the asylum officer can look through it and see, you know, why you're submitting each one of these documents and what, you know, points they're intended to make. That way, you know, if they don't have time to read your entire filing, you know at least that they can look through this and see what is important to your client's case. You're also going to have to draft some sort of legal document. If you are at the asylum office, this will take the form of a cover memo, and if you're at the immigration court, this is going to be a brief. This is going to be the place where you lay out the legal argument and sort of combine all of the other elements that we've been talking about before, the corroborating evidence, the affidavit, and the case law to present your client's asylum case. It's important to keep an eye on the length of this. In immigration court, the brief must be limited to 25 pages. This is a relatively new rule at immigration court, so if you know you've done an asylum case before, or if you have colleagues who have done them in the past, they may not have had to deal with this new page limit, but now everything has to be limited to 25 pages. And for cases at the asylum office, we generally recommend that the memo be about 10 pages. Now, one of the most important things when you are drafting your brief or memo is that you address each of the asylum elements and you do not conflate them. This can be tricky to do because many of the elements are interrelated, but it is really important to deal with each one separately and in turn, and that you have a separate section for each of the elements. Be really strict with yourself about this while you're writing, even if sometimes it feels like your case is getting a bit repetitive. For example, if you are talking about a couple of different protected grounds, say you have a particular social group, women in El Salvador, and you're presenting a second particular social group, which is women who defy gender norms in El Salvador. It's true that when you're discussing each of these groups, it may seem similar, but it's important to explain why each one would be viable. You don't want to mush them together. You're obviously going to have to include case law. Most of our cases are in the Seventh Circuit, and so we highly recommend that you focus on Seventh Circuit case law. There is a lot of it, and much of it is favorable for asylum seekers, so we highly recommend that you rely on that. Additionally, the Seventh Circuit has taken quite a different approach to certain aspects of asylum law, such as particular social groups, to other circuits and the BIA. So if you are in the Seventh Circuit, you're going to want to rely on Seventh Circuit law rather than cases issued by the Board of Immigration Appeals. Obviously, if your case is outside of the Seventh Circuit, you should pay attention to the case law in your local circuit. We ask to see a draft of your brief or memo before you file it. We generally ask that you send it to us 5 business days before your filing deadline. That gives us enough time to review it and send you feedback so that you can incorporate that before your filing deadline. The last thing that is important is that you preserve all possible arguments and claims for relief. This is particularly important at the immigration court level. If you don't raise an argument at the immigration court and your case ends up on appeal, then you are going to be limited to the arguments that you've already made. And we do have an additional webinar about presenting claims, and there's a link here in the PowerPoint. When it comes time to file, there are a couple of things that you're going to want to keep in mind. At the immigration court, you will want to follow the immigration court practice manual. This is available on the immigration court website, and it lays out the rules and preferences of the immigration court in terms of how you format things and other other logistical points. Follow that carefully. The court will get annoyed if you diverge from what they've asked you for. You, again, are going to want to have your index of all the documents that you're submitting. You're going to want to annotate that, particularly with your country conditions evidence. You'll want to highlight important information in the country conditions reports, and you can put the really important quotes in your index so that the judge can see it right away. In immigration court, you're going to have to paginate your entire packet consecutively and have alphabetical tabs on the right-hand side so that you can find documents very quickly. At the asylum office, you're going to file your supporting documents directly with the Chicago Asylum Office. They ask for 2 copies, and if there are derivative children or spouses, you'll have additional copies for each of them. And in court, you have to file at the filing window and at the Chicago Immigration Court, and you have to serve a copy on the government as well. So timing can get a little bit tricky with asylum cases. At the asylum office, if your client filed for asylum before 2018, we really don't know when they will be scheduled for an interview. In 2018, the policy for scheduling interviews changed to a last in, first out policy. So folks who filed before 2018 are kind of in limbo, stuck in a backlog somewhere. For all filings after 2018, generally you would receive an interview within a few months of filing your asylum application. However, because of COVID, things are moving a little bit differently. But generally, you get a notice of your interview 2 weeks before the interview is going to be scheduled, sometimes longer, but generally 2 weeks. 1 week before the interview, you want to file all of your supporting documents, and then you will receive a decision anywhere from 10 days to 6 months after the interview takes place. The asylum office has resumed scheduling interviews, and they've been doing so since June, and they have some COVID procedures in place to limit exposure. And, you know, some asylum applications are taking longer to get interviews, likely because of COVID complications. In immigration court, timing really varies depending on the type of case and which judge you're in front of. Detained cases move much faster than non-detained cases, and the immigration court in Chicago has a very large backlog of cases. You will be scheduled for 2 different types of hearings if you are in immigration court. The first is a preliminary hearing called a master calendar hearing. This is generally where you will address any of the allegations made in the notice to appear and, you know, let the judge that you know that you are requesting asylum. That's when the judge will schedule you for a merits date, a merits hearing date. So it can take a very long time to get to your merits hearing date, but again, the timing really will vary depending on, you know, which judge you're in front of and what the situation is at the court. That has become a bit more complicated now because of COVID-19. The court has resumed hearing merits cases. So they are doing full merits hearings, but they, as part of their COVID-19 precautions, not all of the judges sit on the bench every single day. They alternate. So we are seeing a lot of rescheduling and scheduling confusion as they're trying to accommodate the new judge schedules. So it is very possible that your hearing will get rescheduled or canceled with relatively short notice. You know, if you have a hearing coming up, you can talk to us. We'll talk you through what you will need to do to check the status of your hearing. And it's important to keep checking to make sure that your case is going ahead as planned. During COVID-19, the Chicago Immigration Court is not doing master calendar hearings to reduce the number of people who are in the court at any one time. So regardless of where you are in the process, the affirmative side or the defensive side, while your case is pending, there are several important things that you can do to keep things moving. First and foremost, you're going to want to maintain contact with your client. You know, even though cases can be pending for a very long time, sometimes as much as a couple of years, developing a rapport and maintaining contact with your client is going to be very important. As Rachel talked about when she was discussing affidavit prep, you know, these are very traumatic and difficult things for your clients to talk about. And so, you know, the more comfortable they are with you, the easier it's going to be for them to tell you what has happened to them and give you the details that are going to be crucial for their case. So if you have the time, you know, work slowly through it, talk to them on a regular basis, and let them get comfortable with you so that affidavit prep and testimony prep goes more smoothly. Also, your clients are going to be very anxious. They've been through a lot of really difficult things in their home country. They've been through a difficult journey to the United States. They may be separated from their families or uncertain about whether they're going to be allowed to stay in the United States. So if you disappear for an extended period of time or don't get in touch with them, they might start to get very, very nervous. A good thing, even if there's, you know, nothing that you need to do or no updates, just get in touch, let them know that you're still checking, and you'll let them know when anything gets scheduled. You can also determine what evidence is going to be important and available and start to gather it. This can take a really long time, especially if you have to get documents from abroad or affidavits from family members or friends who are living abroad. One really crucial point is if you're getting witness statements from family members who live in other countries, you'll want to do that as soon as you possibly can. It has happened before where, you know, or to give you an example, there was one asylum applicant who wanted to get a declaration from his grandmother, who had, you know, witnessed several of the important events that led to him seeking asylum. And you know, his attorneys began the process of interviewing her to get a declaration, but before they could finish, she passed away from a heart attack. And so they were not able to present an affidavit from his grandmother. Obviously, this is an extreme scenario, but it can happen that witnesses who might be available when you start working with your client, something happens to them and they're no longer able to talk to you when you get closer to your hearing or your interview. So it's best to get on those things early while they are available. You can also connect your client with a therapist or a doctor for medical and psychological evaluations if appropriate. And we can help you connect you with professionals who provide those. If your client is in immigration court, you're going to have to request a biometrics appointment. You are responsible for setting up a biometrics appointment for your client in immigration court. And you know, you can reach out to us and we'll explain to you that process. But it can take time to get an appointment, so that doing it early is best. If your client is at the asylum office, USCIS will automatically schedule them for a biometrics appointment. Lastly, you can file a work authorization application for your client when they become eligible, and make sure to stay on top of renewals. And I'm going to talk more about that shortly. So work authorization is really crucial for most asylum seekers, but eligibility is currently in flux. Before August 25th, some of you may have heard about the asylum clock. Eligibility depended on what your client's asylum clock read. So before August 25, asylum applicants were eligible to get employment authorization after their application had been pending for 180 days, and they could apply when their application had been pending for 150 days. The clock would stop if the applicant caused a delay, such as requesting a continuance or requesting that their interview be rescheduled. After 8/25, the government passed new regulations that determine eligibility for work authorization. And they've gotten rid of the asylum clock and now say that asylum seekers are eligible after their application has been pending for 365 days. They've also introduced a new series of bars to employment authorization eligibility. Now, this rule has been partially enjoined, and so if you think your client might be eligible for work authorization, you should talk to one of us at NIJC so that we can look through to see which rules apply to your client and what steps you will need to take. We also have an employment authorization FAQ on our website, and we highly recommend that you look at that as well. Your case file is also going to have information about when your client becomes eligible for work authorization. And again, just contact us for more information on how to proceed. As confusing as work authorization has become, it is still a life changer for clients and their families, so it's important to keep that in mind. When the time comes for your asylum office interview or your merits hearing, you're going to have to prepare your client. Now, the process is going to look a little bit different depending on whether you're at court or at the asylum office. At the asylum office, your client will be sitting in an office being asked questions by an asylum officer. You will have more of an observer role in that interview. And at the end, you will be given an opportunity to ask additional questions or make a final statement. At immigration court, the merits hearing, it really looks like a trial. Your client has to get on the witness stand. You have to do a direct exam. The government examines them, and then you will make closing statements. So you're going to want to explain that process to your client. One important thing to note is that at the asylum office, formerly you had to bring your own interpreter for your client if they required one. Right now, because of COVID concerns, USCIS is providing all interpreters. So it's important to practice either the interview or the merits hearing. Generally, we recommend 3 practice sessions. One full preparation where you're asking questions, you discuss the answers, things that your client did well, things that you want them to work on or include. You'll want to have another practice session where you ask really tough questions or give them a really difficult cross-examination so that they can get used to a more aggressive interview or cross-examination. You'll want your final preparation session to really just be a confidence builder and have it very close to the merits hearing or the asylum interview. We recommend preparing with open-ended questions. It is important that you make sure that your client understands all the elements of asylum, what they're going to need to prove, and your strategy for how you're presenting the case. If they have a better understanding of what information needs to come out for them to be successful, they're going to be able to better answer your questions or the asylum officer's questions. You want to manage your client's expectations and make sure that they know what to expect on the day, and also explain to them, and empower them to answer questions with "I don't know" if they don't know the answer to a question. Make sure that they advocate for themselves if they don't understand a question or didn't hear a question properly. So after, if you're at the asylum office, after you get the decision, if asylum is granted, that's fantastic. You'll want to let us know immediately. There are certain benefits that your client must apply for within 30 days. Afterwards, you'll want to get your client work authorization, social security card, and access to their benefits. And you'll want to advise your client to contact us for help applying for derivative family members who may still be in their home country. If asylum isn't granted, you will get referred to the immigration court for a de novo review. While that will be disappointing for your client and for you, it's not the end of the world. You get another bite at the apple at immigration court. The Department of Homeland Security will issue a notice to appear, which places your client in removal proceedings, and your client will get to try to apply for asylum one more time in a defensive posture. Let us know right away if you get referred, and we'll be able to help you regarding timing and what the next steps should be. If you're at the immigration court level, at the merits hearing, if asylum is granted, again, fantastic. Let us know, and the same 30-day deadline for benefits applies. You're going to want to obtain your client's I-94. This is the document that says that they have been granted asylum status. The court doesn't give this to you directly, so you'll have to go through USCIS to get a copy of it. And then again, you'll apply for work authorization for your client, a social security card, and any other benefits that they are eligible for. And you'll also let the client know to contact us for help applying for any family members who are outside the country. If asylum is denied, make sure that you reserve the right to appeal at the immigration court hearing. Let us know immediately, and then we'll discuss with you what an appeal to the BIA would look like. After your case is over, we hope that you had a good experience, and we'll take on another case, that you'll recruit your colleagues and do more advocacy for access to justice for immigrants. And of course, if you feel so inclined, you can donate to help expand access to justice for immigrants in our service area. So that is it for our training today. I don't know, Ashley, if you want to.
Yeah, thanks everybody so much for sticking with us to the end. We know we were at a couple minutes late, and we hope you all thought it was worth it, and now have a lot more information about how to present your case and work with your client to achieve a successful result. Before we sign off today, a couple quick things. We would love if you would fill out our survey to tell us how we did today in the training. So you can either use the QR code here, or I am also putting in the link to the survey into the chat box right now. As I mentioned earlier, after today, we'll be sending CLE certificates via email and case lists as well. But if you're interested in taking a case even before then, please don't hesitate to reach out to Anna, whose information is here on the slide. And then finally, I just wanted to flag that tomorrow evening, we're having our virtual pro bono celebration. So if you are a pro bono attorney, we'd love to celebrate you. If you want to hear more about what we're doing, what our pro bono attorneys are doing, please go to our website and you'll find more information about registering so you can attend this event, where we'll be giving an award to our Rookie Pro Bono of the Year. So thank you again for joining us. We'll stay on for a couple more minutes in case anybody has any questions, and then we'll sign off, and the recording of today's training will be available on our website very soon. All right, it looks like there aren't any questions, so we're going to sign off. Thank you again, and we hope you have a good rest of your day.